Yeah, with anybody over there, there's like Tammy and Mish and.
Tammy and Mish, and gosh, everyone's still there. Keeping them chained down so they can't go anywhere.
Anything cool all left.
I think otherwise, I didn't really, Tammy and Mish, obviously Ryan, Andrew, and me. I don't think there was anyone else that was over it. Right, Carol, you were there. I hope I'm not missing somebody. If I am missing somebody, then I'm gonna feel bad.
Yeah, well, I probably won't tell them.
You run into Mark at all?
Yeah, he's, I haven't got a regular schedule there. So, it's not daily or anything like that, but yeah, I still run it. Yeah. I shut this off, so things that were open are not open anymore.
The Honorable Court of Appeals for the 7th District of Texas is now in session.
Please be seated. We saved the best for last. I apologize that we're running a few minutes late. I'll do a better job of keeping you all on time. The court will call cause number 0724-00285-CB. Anthony Ferguson, doing business as Ant Farms Appellant versus Louis Dreyfus Company, Cotton LLC, Appellee. What says appellant?
Kinsey Johnson, representing Anthony Ferguson, DBA A2 Farms, present and ready.
Thank you. And what says appellee?
Appellee, during a letter appearing for Louis Dreyfus Company, Cotton, known as Allenberg Cotton, and I presume the court has been made aware of
Of your co-counsel. Yes. Well, welcome, Ms. Belair.
Thank you for accommodating me on that.
Sure. And you'll each have 20 minutes to argue, and then Mr. Johnson, you've got an additional 5-minute rebuttal. Okay. Go ahead.
It please the court.
Mr. Johnson.
Counsel. On behalf of my client and myself, thank you for taking the time to consider our appeal today. This dispute concerns an acreage contract, which is a statutorily defined and regulated contract under the Producer Protection Act of Texas Agriculture Code, Chapter 104. That was enacted by House Bill 338 in 2017. The threshold issue in this case concerns whether Texas Agriculture Code Section 104.003 bars a cotton purchaser suit against a cotton producer under an acreage contract when it is undisputed that the producer delivered to the purchaser all of the cotton grown on land specified in the contract. If the purchaser suit is not barred, then the next issue is whether the purchaser met its burden of proving recoverable damages by sufficient evidence. As this court has recognized, In construing a statute, the appellate court's objective is always and only to ascertain and give effect to the legislature's intent as both expressed and implicit in the enacted language. Here, we have the benefit of having the express legislative intent for the Producer Protection Act in House Bill 338. The bill analysis expressly states, informed observers note that the practice of agriculture and the related industry can be unpredictable and that farmers and producers are often unable to accurately predict crop yields, which has led certain acreage contract disputes pitting large multinational agricultural product buyers, such as Allenberg in our case, with dedicated litigation budgets against much smaller producers and farmers, such as the appellate in this case. House Bill 338 seeks to avoid these disputes by providing for a contract type disclosure for the purchase of an agricultural product. This express legislative intent goes on to state House Bill 338 amends the Agriculture Code to require a contract between a producer and a purchaser regarding an agricultural product to clearly and conspicuously state on its face that it is an acreage contract or a quantity contract as applicable. House Bill 338 prohibits a purchaser from filing suit against a producer under an acreage contract unless the producer knowingly fails to deliver to the purchaser all of an agricultural product grown on specified land as provided by the acreage contract.
Have there been any cases that have defined the word knowingly there? Is that a fact question, or how do we know if something is knowingly failed to deliver?
So, Your Honor, as far as this statute, it has not, there is no case on it, but I will, it is undisputed in this case that there is no claim that Mr. Ferguson, the appellant, knowingly failed to deliver. It is admitted and undisputed in this case that he delivered all the cotton produced on the contracted acreage. There's sworn testimony that's in the record, which I can find here shortly, where Allenberg admitted, again, in sworn testimony that they are not making the claim that Ferguson knowingly failed to deliver anything. It's undisputed he delivered everything he produced. The issue,
Clear something up procedurally for me.
Sure.
So there's the petition that's filed with the deck action. In it saying 104, this 104, the statute we're talking about was unconstitutional. Then y'all file your 91A and your plea.
yes,
Then I see in the clerk's record, there's like an email letter ruling. And it says, hey, I'm denying the plea. And like I said, I think the statute is constitutional on its face or is applied, write up an order. Then there's an order, in the order 1, 2, and 3. 3 says, hey, it's constitutional essentially. Was there a hearing somewhere in between there?
No, Your Honor. So it was argued at the 91A hearing. The constitutionality of the statute was brought up. We argued that it was constitutional, and the court ruled that, yes, it is presumed constitutional. There was an order that was circulated based on the letter ruling, and then the order was then entered by the court, which stated that for the purposes of this case, the statute is constitutional.
Was the Attorney General's office involved in that?
Not to my knowledge, Your Honor.
Is there, normally they'd be given notice?
I saw in the deck action the provision that they were given notice
And
was there. I just didn't know if anybody intervened.
no one, we never saw anyone make an appearance from the Attorney General's office. And on appeal, for purposes of this appeal, there is no challenge to the constitutionality of the statute.
Was
So
the deck action tried at the final trial or anything, or it was just gone after the 91A, I guess?
that's correct. It was not challenged again at trial. And again, for purposes of this appeal, the constitutionality has not been challenged.
There's no cross appeal on that issue.
Correct. So as it stands for, and I understand this is not the only case that is, I guess, pending before the court. I don't know if briefs have been done, but that are coming before the court on this issue by Allenberg, just different farmer, but same contract, same gen, same notice provision issue, same weather event. But our case was a little bit different than some of the circumstances in that, as far as what evidence was proven up or what was not proven up in some of those issues. There is a split between the district courts right now. In our case, the court decided that on this threshold issue, the statute that says the case is barred does not bar the case. In Judge Grace's court, which is it the 72nd now? In that case, the court ruled that yes, the statute does bar the suit. And again, I don't want to stick my neck out too far on that one, but I believe it was the same thing where there was no dispute over the farmer delivering all the cotton that they produced on the contracted acreage. It was all just a dispute over the notice provision. So
Procedurally, when is this presented? Is it presented as an affirmative defense? Is it presented motion for summary judgment? At what point did this get before the court, and where are we
Your
at
Honor,
with that?
we presented it every way. We presented it in a 91A motion. We said alternatively, if it's not dismissed through 91A, then we did it as a plea to the jurisdiction. We also filed a motion for summary judgment on it as an affirmative defense. And then at trial, since it was a bench trial, we reiterated the court and asked the court, instead of us saying the same argument for the third time, to take judicial notice of the motion for summary judgment pleadings that the court had very soon, right before trial, had issued a ruling on it. So the trial to the bench was primarily on the damage issue, and just asking the court again, as the court had just considered our arguments on the statute.
Did you include it as an affirmative defense in your pleadings under Rule 94?
Yes, Your Honor, we did. We pled it. We moved, like I said, we moved for it every way you can plead and move for it, and had hearings and submitted motions for summary judgment, and now we're before this court.
Is your main argument that we should treat it as jurisdictional instead of an affirmative defense?
Your Honor, as we sit here at this point, for the purposes of my client, I don't know that it matters. For our case, it's not an issue as far as whether my client knowingly failed to deliver. That's not an issue in the case. So for that perspective, I think for jurisdictional, if there is no claim in the case and it's undisputed that it doesn't meet the statutory requirement, then to me that would be potentially jurisdictional. But in our case, if it's an affirmative defense, well, then it's conclusively proven and admitted, and it's undisputed in our case that our client, again, did not knowingly fail to deliver anything, and did in fact deliver everything that was produced. So as an affirmative defense, it would still bar the case.
What evidence did you rely on in your summary judgment to establish it as an affirmative defense?
Deposition testimony, Your Honor, and let me find that right quick.
Well, let me ask you a follow-up question while you're looking. I think one thing that it would affect, going the jurisdictional route versus the affirmative defense route, if the court doesn't have jurisdiction, then the case is dismissed and we don't get into anything else, including your cross motion for attorney's fees. We can't determine who a prevailing party is because we don't have a final judgment. All we have is a dismissal. Because the court couldn't hear it.
In Your Honor, I don't disagree with you on that. I don't know that has been briefed on appeal. I think we've primarily been treating it as an affirmative defense issue at this point, since it has gotten all the way here. So I think for purposes of our briefing and our positions that we took, we've been taking it as an affirmative defense position. But I don't have a definitive answer for you of, well, does it have to just be jurisdictional first. I don't know the answer to that question. Your Honor, so to answer the question of, so for summary judgment, this is clerk's record 89. It is technically, so it's 89, but the deposition page is 117. It's lines 11 through 16. I asked the question. Bear with me, okay? Again, just trying to make sure I'm clear on all of Allenberg's claims in this case. My understanding is that Allenberg is not claiming that A&T, which Ferguson, right, knowingly failed to deliver any cotton produced on the contract acreage. Is that correct? Sworn testimony answer is that is correct. So again, from inception, there has never been a claim that Mr. Ferguson failed to deliver. We do have testimony that's cited in our brief, again, at trial that was undisputed, where Mr. Ferguson testified that these were the contracted acres. He understood that he was contracted to deliver all cotton produced on those acres to Allenberg, and he in fact did deliver all cotton produced on those acres to Allenberg. And so that's established.
Evidence.
That is in, that is in the court's, the trial record. So that is 3 reporters record, 35, 25 through 36, 5, I think. Let me double
Because in
check
the
that.
summary judgment stage, if I remember the record correctly, you do rely on that deposition testimony, but that's kind of the inverse. It's the evidence of, hey, they're just not making this claim, but it's your burden to establish it as an affirmative defense. In other words, you have to put forward evidence that you did deliver all of the acreage or the product grown on that acreage.
So, Your Honor, I understand, I follow. However, I think for our case, I guess I can't say it was stipulated, but it was agreed and undisputed and conclusive that that was not the issue. Allenberg in the record made multiple arguments that we're not arguing that. That's not an issue. We don't dispute it. So, I mean, yes, I guess we do have to point out to the court that it's undisputed that he knowingly delivered everything that he produced, which we did. But again, for purposes of trial, we did prove it up again that he did in fact deliver all cotton produced on those acres to Allenberg. And again, my understanding is that that may have been in Allenberg's pleadings as well. But again, throughout there was never a dispute. It was always agreed and conclusive that he did deliver all acreage. But regardless, it was proven at trial for sure.
Did you want to address your damages argument briefly?
Yes, thank you, Your Honor. So again, in this case, because the statute is presumed constitutional and under the plain language application to our case, the statute should bar the case because we did deliver all of the crops. Now, if the court does determine that Allenberg's suit against Ferguson under the acreage contract is not barred by the statute, this court should still reverse the trial court's judgment and render a take-nothing judgment in Ferguson's favor because the trial court erred there. I want to kind of keep this to the main issues, but the trial court erred in finding that Allenberg's damage evidence was legally sufficient to support an award for breach of the notice provision and entering a judgment in favor of Allenberg when there's no evidence that supports the findings on which the judgment rests. The trial court committed reversible error by finding that Ferguson contracted with Allenberg to deliver a certain quantity of bales. We briefed, and I'm sure the court has seen that the statutes define exactly what a quantity, or sometimes commonly referred to as a bale contract, is, but a quantity contract or a an acreage contract. Again, it's undisputed, was admitted in our case. This is not a quantity contract. The undisputed conclusive evidence admitted by Allenberg establishes that under the acreage contract, Ferguson did not guarantee delivery of any yield, and that of any quantity of bale, and that Ferguson's delivery of less than his estimated yield was not a breach of the acreage contract. They testified that Mr. Ferguson was only obligated to deliver all cotton he produced on the contract acreage, which again, it was admitted that he did. And in its brief, Allenberg concedes that the trial court erred by finding that Ferguson contracted with Allenberg to deliver a net 1,980 bales of cotton because, again, this is in Allenberg's brief. They concede that the acreage contract did not require Ferguson to deliver any cotton. So we have that established. The next part of it is that the trial court committed reversible error by finding that Allenberg's damage evidence was legally sufficient to support an award for a breach, and that no evidence supports what's in the judgment. So even if there is sufficient evidence of a breach of the contract, so a breach of the notice provision, Allenberg cannot recover damages unless they meet their burden of proving both the fact and the amount of damages by competent evidence. It must be with reasonable certainty, based on objective facts, figures, or data, and predicated on one complete calculation. The damages must be traceable to the specific breach and result from it. Here, Allenberg alleges that Ferguson breached the following inconspicuous notice provision that's, if you can find it, it's in paragraph 8 of the acreage contract. It says, if seller has a change in planted acreage or in yield or an estimated yield from planted acreage due to any reason, including but not limited to weather after contracting, seller must notify buyer as follows. If occurrence takes place after contracting, seller will notify buyer when seller notifies its insurance agent. Buyer will be making marketing decisions based on information from seller, and seller will be responsible for buyer's losses resulting from seller's failure to timely inform buyer. Allenberg admitted, again in sworn testimony, that its damages were limited to the losses suffered as a result of Ferguson's alleged violation of this notice provision. So Allenberg had the burden of proving its alleged damages are traceable to and resulted from the failure to timely inform them of the crop loss when they notified their insurance agent. At trial, their designated corporate representative again testified and agreed that Allenberg's position is that they would have been able to lift their hedges and either would not have sustained any damages or that those damages would have been less if they had been notified at a prior date. Again, the claim is, had Allenberg been notified on the date Ferguson notified his insurance agent, could have lifted their hedges for lower, maybe not even had any damages. So
the court addressed that. They said they failed to mitigate some damages.
So that's
What's
part
your
of it,
main
right?
argument on why the damages are wrong?
Sure. So the evidence in this case, and again, this is Allenberg's testified position, is that Ferguson notified his insurance agent of crop loss on August 9th of 2021. And that was the date that Ferguson was required to notify Allenberg under the acreage contract. But they did not actually receive notice until October 5th of 2021. So here's the issue. The issue is that the measure of damages that Allenberg had the burden of proving was the difference between the price of cotton on August 9th of 2021, which was the day Allenberg testified that Ferguson should have notified them, and the price of cotton on October 5th of 2021, which was the date that Allenberg was notified. Again, the issue, why that's of so much importance, is if the price of cotton on August 9th of 2021 is the same or higher than the price on October 5th of 2021, then Ferguson's delay did not cause any damages. There were no damages if that happened. However, Allenberg admits that they presented no evidence of the price of cotton on August 9th of 2021. I provided the testimony to the court that goes through that they don't know the price of cotton from June 26th to October 5th. They don't have any calculations for it. They don't have any records. They don't have any evidence. They don't know what the prices were. They don't have any calculation of what the differences were. There is no damage calculation. Instead, what was used by the court and the evidence that was presented by Allenberg was that on March 1st of 2021, which is in close proximity to when the contract was entered into, they placed hedges at $0.8655 per pound. And that was the price on that date. So they are using the initial price that they locked in for Mr. Ferguson, subtracted that from the price on October 5th of 2021, which is $1.06, and they came up with $0.1945 per pound that they had to pay more on. Multiplied that by 500 pounds, that's $97.25 per bale. Multiplied that by, again, they claim that my client's liable for 1,589 bales. That comes out to the $154,000 number. The problem, though, is that damage calculation, again, it's improper because it is not related to the damage allegation. It's not related or traceable or tied to damage from failure to notify on August 9th of 2021. So the price of what I just said, the 0.8655 cents per pound set out in the acreage contract. It's important to note that's the amount that Allenberg was obligated to pay Ferguson for any bales he delivered. In it, it was up to 1,980 bales. If Ferguson delivered less than that, again, this is not a guarantee. If it is more than that, well, Allenberg's only bound to that price to 1,980 bales, but it has nothing to do with their damage award. Again, if the price of cotton is the same or higher on August 9th of 21 than it is on October 5th of 21, there are no damages. Similar, just one more example. If the price of cotton on August 9th of 2021 was $1, then Allenberg would have only been damaged $47,000 in a little bit, not the $154,000. And I can go through.
And we'll let you
Sure.
continue with that when you come back up for your 5-minute rebuttal. Thank you.
Thank you, Your Honor.
Mr.
Please,
Delaire.
court.
Okay.
Many things we agree upon. This certainly is an acreage contract. It certainly is a contract where we were provided with information indicating what the farms produced historically. And that's important because of the hard to find Section 8. And Section 8 is where the court needs to direct its focus in this case. Section 8 is where we have, if you will, an expectation contract. We were told that we would be getting, I believe the number was 1980. And based on that, we placed hedges back in March. And those hedges did two things. One, it fixed the price of cotton that we were going to pay to the ant farms. And it also fixed the price of cotton for what we had to deliver. And we, at that time, obligated ourselves to deliver those 1,980 bales. And we placed the hedge on to minimize our risk. And by minimizing the risk, it keeps the contract within sensible bounds, which is one of the things we don't seem to want to talk about here when we want to talk about the statute. This is not a delivery contract in the sense that we're complaining about we didn't get a certain amount of cotton delivered. There's no question that these folks had a hail event and that as a result of the hail event, a significant portion of the farm was damaged. And that's why there was a difference between what was expected and what was delivered. And it's the expectation that's important, because it's the expectation that they had to give us notice about. And if they had given us notice of the change in the acreage or in the production per acreage in a timely manner, then Allenberg could have lifted its hedges in a timely manner and probably not sustained any damage. But notice was not given until months after the fact, months after the opportunity to lift hedges and tend to business and reduce the risk in a timely manner at the time that they reported the losses or the change in expectations to their insurer. They didn't do that, and they left the risk factor all on Allenberg, and that factor never changed until October. And it's
Can I ask you a question related to the statute? Your brief, you argue the absurdity of applying section 104.03. And you
Correct.
talk about, I think you mentioned discretion 3 or 4 times. We don't have any findings of fact regarding what the trial court did on why it didn't apply 104. I'm just curious where we are on that. What prohibits us from saying we're going to apply the plain language and you're out of luck?
The decisions were made in issues that are not before the court. Those decisions were attacked early on in the case, and neither party is questioning how the case was disposed of, either in summary judgment proceedings or the jurisdictional proceeding, and those issues are gone. So I think the court has to confine itself to the record that is in the 3rd volume of the reporter's record. And I think in that sense, the court does tell us what numbers it used, how it got there, and it indicates that it did not consider the statute being unconstitutional. To back up and address a question that each of you may have had, I don't think any party ever gave notice to the Attorney General. I know that the Attorney General never appeared in this case.
In your petition, you allege that you did give notice or complied with the statute.
Mistakes are made, and that is one of them. As near as I can find no notice to the Attorney General in this or the other case that we've alluded to, which I don't want to spend a lot of time on, but both petitions made the same representation. Somebody dropped the ball.
Do you consider your deck action have being dismissed with the 91A procedure? I'm a little confused procedurally on how that happened.
The deck action is indisputably gone at this point in time by virtue of the quote unquote Mother Hubbard cause that says you didn't ask for this and I'm not giving it to you, and all relief I'm not giving to you is gone. So I think the deck action is gone. Yes.
It wasn't tried either. I mean,
no, Your Honor, I don't believe it was tried.
So the arguments of whether or not it was constitutional thing, that's not really before us.
The constitutional issue is not before you in this case. It will be before you in the companion case, where I have given notice to the Attorney General, myself, and so I'm sure that notice has been received by the Attorney General. I don't know if they've made an appearance in this case, but we made both this court and the Attorney General aware, and we also brought the Attorney General into the trial court proceedings, because I believe I gave him the notice in the trial court proceeding, and then attached that notice as an exhibit to the notice of appeal.
In this case, in your response to their plea of the jurisdiction, you argue that the statute should not be treated jurisdictional. Instead, it should be treated as affirmative defense. Seems like the trial court went with that argument. They later file a summary judgment treating it as an affirmative defense. It's denied. And then if we limit ourselves to volume 3, it appears from the record that they try to establish it as an affirmative defense. do you not think they established it as an affirmative defense, or is your argument that it falls outside the statute?
Your Honor, I think the statute is a result-oriented statute that was poorly thought out and poorly developed from the get-go. I do not believe that it is a jurisdictional statute because courts typically do not construe statutes like this as jurisdictional. I personally don't believe that it is an affirmative defense because I believe the statute puts the burden on us and says we cannot bring a suit unless we show knowing intent. And in this particular case, I think we're all on the same page. There was an absence of a knowing intent to not deliver cotton. Unlike what happened at the time that statute was done, there were farmers who knowingly had an intent to forego the one contract, take their cotton down the road and have another gin develop it and everything else. And so there was all kinds of evidence of farmers having a knowing intent not to deliver. And I think that was where the statute came about. And that's based on our experience with the attorney who ended up writing the statute.
Okay, so then here's where I need some help. I'm ignoring the jurisdictional side of it for now.
Okay.
I'm looking at volume 3 of the trial and treating the statute hypothetically as an affirmative defense. And they put on evidence that they delivered all the product they had. The other side, your side, does not dispute that. How would that not establish it as an affirmative defense and kill the claim?
Once again, Your Honor, this is not a traditional affirmative defense. The affirmative defense and there are a number of them that are iterated in the rules of civil procedure. This is not one of them, and it's not an offense that ought to be enforced. And here's the why. The why is that when you have a situation like this, where cotton was lost to a hail event and not delivered because of that loss, this court shouldn't look at the quote unquote delivery. They should be looking to the expectation of what was expected to be produced and delivered. And had the notice been timely given, it should be construed in that context as opposed to the context of the simple words of the statute. Because
so what do I do with the statute? It's not an affirmative defense.
I think that's the point where you have to look at the cases that I've cited that says there are constitutional bounds that you have to look at. And while constitutionality is not a quote unquote issue in this case, common sense tells you you ought to look to those bounds anyway.
One other way that we've seen cases where an affirmative defense comes up like this is in the course of limitations. Somebody suits filed, defendant pleads this, this is outside the statute of limitations. Then the plaintiff comes back and says discovery rule shouldn't apply. The burden would be on you at that point, right? To show we did not discover this in the course of reasonable diligence. And the courts haven't had any problem applying that as an affirmative defense.
I hate to give a knee-jerk answer to that because I understand what you're saying, and certainly within the context of you plead the affirmative defense, but you also have the duty to plead limitations. You're correct within that context.
And it may be something you need to think about and supplement or something. I'm just trying to figure out. In those cases, we don't say, well, we're going to ignore limitations because the burden's on the wrong party.
I don't think you end up ignoring, but it seems like, and I don't have a good working knowledge of how many cases I've actually read that dealt with that, but it seems like more often than not, you're able to show the inapplicability of the discovery rule for one reason or another. And so you're able to address their counter affirmative defense, I think is what that really is. The limitations is the defendant's affirmative defense, and I think the discovery rule, which are required to plead, and so it's kind of an oddball circumstance, but I think it's still their duty to come forward showing that the discovery rule is applicable. I hope that.
Sure. Yeah.
Okay, and that's why I think it needs to be looked at in this case as looking at the expectations, because absent those expectations, you would never have an opportunity to shift the risk for any point in time, which is also why to address the argument about the October 9th, excuse me, August 9th date. Here again, Allenberg had no opportunity to do anything at that point in time. And Allenberg did agree to cover the risk for that brief period of time, provided they had the notice. But you don't get to say, oh, wait, if we'd given you the notice, we win because you didn't have any damages. That might have been a risk that Allenberg assumed, but they didn't assume to learn of something after the fact and then come in and say you get to have your cake and eat it too in this case, which is I think what they're after. It's just a case where the numbers were there. The October 9th date, there was a significant amount of damages, and we laid those damages out in the brief. And I could pull the brief up and run through the math again with you if you'd like, but I think I'd prefer to rely upon the brief. I don't think there's any dispute that there were like 1589 bales that Allenberg expected to receive, did not receive, and that times 50 bales gives you a poundage, and that times the difference between the March number of 85 cents and the subsequent number that they were able to use in October 9th, multiplied by all those pounds gives you the number. And so we believe there is sufficient evidence to uphold the award that the court gave. We also believe that construed within the proper context instead of an absurd result that would absolutely gut the contract. There are so many things in this contract that you could never sue for if that statute really means what it seems to say. You could not sue for not using good farming practices. You could not sue for any number of things that are in that contract because you would still have a argument concerning undelivered bales, and it's really not a question of on delivery. It's a question of unmet expectations that they were aware of, that they filed insurance claims for, and left us holding the bag for the entire loss. And unless the court has other questions, I'll be happy to give you back 4 minutes, which is a rare event on my part, probably. Almost makes up for the time he went over.
Happy to give extra time.
Do you have further questions?
I don't have anything else.
Okay, we'll take you up on your offer.
Thank you.
Thank you. Mr. Johnson, you'll have 5 minutes.
Thank you, Your Honor. To address the issue of trial court discretion, as we have cited in our reply brief, under Texas Supreme Court case law, this is Walker versus Packer, 827 Southwest 2nd, 833 at 840. It is well settled that, quote, a trial court has no discretion in determining what the law is or applying the law to the facts, end quote. The court also said it is thus a clear failure by the trial court to analyze or apply the law correctly will constitute an abuse of discretion. Similarly, in Limpencott versus Wissenhunt, it's 462 Southwest 3rd, 507 at 508. the Supreme Court of Texas has held a court may not judicially amend a statute by adding words that are not contained in the language of the statute. Instead, it must apply the statute as written. Not only do we have that, but we have the express legislative intent of the legislature that says why they drafted and enacted this statute. And it was specifically to avoid this type of circumstance.
How much deference do we have to give to that?
My understanding is that
Anybody can get whatever they want to the legislative record. I mean, anybody can say something to me.
so.
Right.
My understanding is that the court is required to look to what the legislative intent is and to analyze and apply the statute in order to affect the legislative intent. The court has before it undisputed legislative intent.
What
There's
was their intent in the statute?
Yes, so I'll quote it for you. They say, and this is again, quote, informed observers note that the practice of agriculture and the related industry can be unpredictable and that farmers and producers are often unable to accurately predict crop yields, which has led to certain acreage contract disputes pitting large multinational agricultural product buyers with dedicated litigation budgets against much smaller producers and farmers. House Bill 338 seeks to avoid these disputes by providing for a contract type disclosure for the purchase of an agricultural product. House Bill
What's your
338.
source on this?
Yes, we've cited it, Your Honor.
What
It
is the
is
source?
House Bill 338, bill analysis, author slash sponsors statement of intent. I believe
I
that
don't
is
think the bill analysis is usually performed by the legislators.
it. In this case, it was drafted, and the legislative intent is from, I believe, Burroughs and Perry, who introduced it, and it was their sponsored bill saying why they did it. And I know that Burroughs was involved in the underlying litigation in 2010, and that was the whole reason that they put this into place again, was because there were the three scenarios, one of which was that Allenberg was involved in, where you had an acreage contract where the farmer is under the understanding I'm required to deliver everything that I produce on these acres to you. I'm not guaranteeing any number of bales. When a weather event comes in or they just yield less, then in that case, the merchant, my understanding is it was Allenberg as well, sued the farmer saying you're liable for the bales that you didn't deliver. And the whole issue was, well, this isn't a quantity contract. This is an acreage contract. So that's why the court, the legislature put this definition in, put the Producer Protection Act in place, and again, did these specific definitions, such as a quantity contract means, and this is 104.0014, a quantity contract means a contract that requires a producer to deliver to a purchaser a specified quantity of an agricultural product, regardless of the amount of product grown by the producer.
What am I missing that I can't see from the record? You filed a summary judgment and you lose. You retry it again. It looks like you prove it up as an affirmative defense, but then the trial court still finds for the plaintiff. Why didn't he go for your argument at all? Did he say it was outside of it? What am I missing?
You're not missing anything, Your Honor. I'm looking at the same thing and I'm in the same quandary as you are. I do not understand. I do not know. I wish I had an answer. I do not. I don't have any answer of what the court looked at. If you go through and look at the letter ruling and the conclusions, you can see based on the evidence that it doesn't match up and it isn't supported. Dates are wrong, amounts are wrong.
Well, the 104 statute's not in whether it was constitutional or not, or
There's no mention of.
Right, and that was because the court determined that it is not barred by 104.003. Again,
Okay. Well, any further questions? Your time is up. Thank you very much.
thank you, Your Honor. Honors, plural.
The case is submitted. We appreciate you presenting your case and we'll be in recess. Thank you.